Hi. In today's discussion, we'll be looking at the breach of duty of care in the thought of negligence. The breach of duty of care in the thought of negligence. You recall that during the introduction to negligence, we mentioned that apart from the fact that there must be a duty of care in the thought of negligence, the second element is that the duty of care must have been breached. The duty of care must have been breached. So today's discussion is focused on that. And I will soon be sharing my slides. Once again, my name is Professor Oluwakemi Adekile, and I would want us to carefully listen to this presentation. Okay, I believe you can see my slides. The breach of duty of care represents the second thing that a claimant in a court of law must plead and prove to sustain a cause of action in the thought of negligence. And in this presentation, you will understand how the court has formulated the test of breach of duty of care. How can you say that a defendant in a claim in negligence have breached the duty of care that he owes to the claimant? And you will also understand in that respect the factors that the court will use to determine the breach of duty of care. So we'll be looking at the meaning of the duty of care, would also be in the thought of negligence. We look at the breach of duty. We look at the factors that the court use to determine this breach and how to understand these factors. A breach of duty of care represents the fact that a defendant has fallen beneath the standard of care that the law has laid down, the expectations of the law in terms of his act or his omission. And in respect to that, the basic premise of that is that it is reasonably foreseeable that what he has done or failed to do falls beneath that standard. We said that reasonable foreseeability is sometimes used to determine duty of care, apart from other considerations that we have looked at. And that in the formulation of the reasonable foreseeability, Lord Ethan talked about doing something that a reasonable and a prudent man will not do, or failing to do what a reasonable and prudent man would do. Okay, so there is a falling beneath the standard of what we call a reasonable man or a reasonable, and you'll be using that term reasonable person, reasonable man a lot during this presentation. We expect that every one of us, as we do go about our daily activities in life, we guard against reasonably foreseeable risks of harms unto others. No, it must be reasonably foreseeable. We are not talking about fantastic possibilities, as one author has said. Is no, we are no, if we look at it in that context, all things are really possible. But we are talking about the ones that are reasonably foreseeable. When you are engaging in an act of omission, when you are driving your car, when you are treating your patient, when you are manufacturing a product that you want the public to use in terms of product liability, you must reasonably foresee the risk of injury to those people. So how do we determine this breach of standard, breach of duty of care? A breach occurs where the standard of care falls below that of the reasonable man. We've said that. I can note that reasonable man's connotation used first in the case of Vaughan and Menlo, and in McQuay and Western Morning News, in 1905 case, the judge said the reasonable man see, we are saying, okay, your standard must not fall beneath that of the reasonable man. That reasonable man was described as the man on the Clapham omnibus in England. The Clapham omnibus was was form of means of transportation then. The average man, that is riding on that omnibus. So in your environment might be someone that is riding on a particular kind of vehicle, or the ordinary person. In Nigeria, you might say, oh, someone that the average passenger on a cab or something, on a danfo or whatever means of transportation. The man on the Clapham omnibus, that is how he was described. Is here. And this, this reasonable man must, how does he behave? How does he relate with a particular set of situations or affairs? And so the standard of care is the standard that a reasonable man would exercise in the context of your particular circumstances. It's in the light of the facts of the case that you determine the standard. How would a person prescribing a drug, how would he or she prescribe the drug in a way that it will not be of injury to the patient that is going to receive it? How would someone that is in charge of a child take care of that child? How would a pilot that is flying a plane fly that plane? In every interaction that man has in society, there is a standard of behavior that is expected. And the law has said, oh, it must be the reasonable man's test. So that idea of a reasonable man is an objective test. He must have done that, he met that standard. He cannot bring witnesses to show I did my best. You are looking at whether your best has met the standard of the reasonable man. We are going to look at that reasonable man again as we go in this presentation. But you must know that the standard is meant to do something. It tries to move beyond your peculiarities as a defendant. It's not looking at your own peculiar situations. It's looking at what an ordinary person, a prudent person in society would do. The reasonable man was described, therefore, as a man in the Clapham omnibus in the English decisions. In some context, the law has said that it is an objective test. It eliminates the personal equation, challenges, peculiarities of this particular defendant who is before the court. That's what Lord Macmillan said in Glasgow Operation Amur. It eliminates, it's not concerned with that. It's rather looking at, the ordinary person. So if, for instance, like Holmes had said, you are a person that has some personal disadvantages and attributes. You are so clumsy as a person that you cannot do some things that ordinary reasonable person would do well. He said, well, in the courts of heaven, those considerations might come into play in adjudging you innocent. But in the courts of men, no matter how natural to you those idiosyncrasies are, and that they are not really your fault, they are just your natural idiosyncrasies. If they are harmful to your neighbors, then they are going to take you to it. They are not going to take it lightly. They will not take it lightly that is the cause of the injury to them, and they may get their remedy in law. So the reasonable man is the average man. Is not as if the court will come to you, expect you to bring someone to the court and begin to show that, okay, you are a reasonable man, how would you have acted in this context? No, he is an hypothetical average adult person. And that's why it says, the ordinary man of natural intelligence who knows about the basic things of life, understands everyday affairs, understands that if I drive too fast on a very busy road, I might injure someone, who understands the daily realities of life. So you look at that reasonable person in the context of the facts before you. Is a legal fiction. You must take care to understand that is a legal fiction. It's a fiction for ordinary person, average person who takes care and control. And like I said, the English description says the man on the Clapham honeyballs. In the American description, it says the man who takes the magazines home and in the evening pushes the lawnmower in his shirt sleeves. Those are decisions that were taken that are almost 100 years old now. But we can contextualize that in the context, in the light of modern society, the average person, maybe probably today we say the average person reads the news on the internet, on their phone, and whatever, because the law continues to evolve with more human development. Is that average man? In Nigeria, in the case of Adigbo and Heji or your state, Kaide just says, okay, he's not the reasonable man. Who is he? He says, is the average housewife shopping for a meal in Sandros Market. For some of us who know where Sandros Market is, the local market in Lagos Island, is not the wife of an executive who is shopping for a meal in Moloni, when Moloni was a major modern, a store like you will have some big stores today. Is the ordinary worker in Kano City onto a local mill and not a senior executive cruising in his air-conditioned car, the plain woman in Okika dress and not the voiceless fashion enthusiast. And if you situate it in the light of modern day, you can then know who they consider the reasonable man to be. And you have other conceptions of reasonable man in cases, both in English decisions and Nigerian decisions. The reasonable man, therefore, is the way the law tries to find and evaluate your behavior, whether it is lawful or not, whether it is beneath the standard that the law wants to set. He is not a real person that you bring to court and say, these are the reasonable men in my society or women, but he's a fictional person, a notional person who is used to represent what is an ideal standard of behavior in society. How should you behave? He's not the person, like some judges have said, oh, would the reasonable person have sped at a speed light? If you say, oh, in a society like Nigeria, for instance, the person would not run the traffic light. You have people that are running the traffic light every day. But that does not represent the reasonable behavior in modern society. Okay, and therefore you cannot say because a lot of people run the traffic light, then because if this claimant ran the traffic light, then that claimant to just bring people to court and show that look, that is the reasonable behavior in a city like Lagos. No, that is not how it is. It is a notional person conceived in the law as to how that person will behave in the society. And court will look at, in trying to evaluate this person, consider the intelligence of the average person, the knowledge, the skill, and how the average person would behave, and then try to. The courts will look at intelligence. For instance, in a case like Yachuk and Oliver Bliss, where someone gave fuel to a child of about 9 years old. The court said that it is a reasonable person will not give fuel to a child because it's combustible. There's no way a child of that age will be able to handle fuel. So the reasonable man is someone that is credited with average intelligence, understanding about basic relationships in life, and as the law has some expectation as to who that typical average person should be and how their pattern of behavior should be. So it's sometimes credited with the strength, with the dexterity of someone has described it as of an acrobat, the perfection, the precision of an acrobat, and the foresight of an Hebrew prophet. That is, he can foresee and say, okay, if I take this step, these are the likely consequences of my actions. In the connotation of the law, the courts have described that person as a reasonable person, as a notional person. So it's in the light of the cases that have been considered in the courts. There are some factors that the courts have recognized as helping to determine whether you have breached the standard of care. That standard of care, from the description of reasonable man, is an objective standard. There are situations where the law would say, oh, like a few situations, they will look at the peculiarities. If it's a child, for instance, you look at of 10 years old, the reasonable behavior expected of a child of 10 years is that of a 10-year-old child, or a child of the same age. So in that context, the court is taking note of the clear fact of the age of the child. But there are some contexts that the court will not take note of your own individual peculiarities. For instance, if you are driving on the road, the law has held that a learner driver is held to the standard of care of the average driver on the road. It is not going to take note of the fact that you just started learning to drive, or you just started driving 2 days ago or 1 month ago. Because I said at earlier teachings that in the law of tort, there are so many policy considerations that come into play, even in arriving at some of those decisions, apart from the principle of law that might have been laid down. And the law recognizes that a car is a lethal weapon. It's a potential killer. If you allow every learner, for instance, to say, because I'm a learner, well, how would our roads be? So by the time you put something like that on the road, you are held to the standard of care of the average driver. If you are a medical doctor and you are practicing your profession, and the standard of care is the standard of the average medical practitioner, practicing the profession, not that of the specialist in a particular field of law that have mastered, just the average practitioner. So in the context of the cases that will come before you, the law will determine whether this person, what is the standard of care expected of that person. When the law has determined the standard of care, like I said, concerning the child, concerning the learner, concerning a doctor, concerning any activity that you have engaged in, you now look at whether you have breached that standard of care, that objective standard. So it looks at these factors, amongst others, the magnitude of the risk. What is the magnitude of the risk? What is the importance of the object you want to attain? What is the standard practice in a particular thing that you have done? And the practicability of the precautions that has been taken. The magnitude of the risk. If you take a case like Barry and Stephanie Borough Council, where a worker who had one eye lost that one eye, because the employers did not, he was not wearing safety goggles in the course of employment. And the court looked at the magnitude of the risk. This person has just one eye. So it was essentially important that that eye is kept safe. And it was not, it became very, very important that the standard of care for that employer is judged against the magnitude of the risk. How great is the risk? The risk was quite great, so the standard of care was quite high, was regarded as very high, and they were reached. They were held to have reached that standard by not providing safety goggles, even if the employee had declined to wear it. There was bolting and stone, where the court said that, look, where a ball had escaped from a pit, and there was evidence that in the decades of existence of that field, there had been no such escape of balls. Then the court was not prepared to hold that the risk was very high. And so the kind of precaution they are taking by having defense and help around the field or a particular perimeter and whatever was not sufficient, was actually sufficient for the risk that they were exposed to. Then they look at the importance of the object that is to be attained. The court will look at the importance of the objects you want to attain. Okay, so what were you trying to do? What was the essence of your activity? What was the project that you were engaged in? And if the purpose to be served is of sufficient importance to justify the taking of that risk, then it's likely to be held that you have not reached the standard of care. Sometimes it may be like, let's take a situation where an ambulance is running exceptionally fast because there is someone in the ambulance that needs medical attention, even though we might say that a reasonable person would drive at the speed of 40 kilometers per hour on that road on an average day where there was no emergency. The fact that the ambulance was driving at 80 kilometers per hour on the same road might be justified by the purpose of saving human life. But that is not a risk that you would take at the expense of killing someone else. You cannot say you want to save one life and then end up, killing others. But we are just saying that it will weigh heavily in looking at whether they have met a particular standard of care. You look at sometimes the approved practice, the standard practice, especially in a particular profession. What is the standard of practice in a particular profession, in a particular engagement, in a particular line of business? Whether you have met that standard, this is how we normally do it. This is how we normally attend to patients with a particular complaint. This is how we normally engage in a particular form of activity. And if a person has made that standard, as a starting point, the court is likely to hold that that person has behaved like a reasonable and prudent man, would behave. However, I must sound a note of caution that the court would not say that because you have met a standard of practice, and if the court looks at that standard and felt that it's so obvious that a reasonable person, a prudent person would not behave in that way, irrespective of the professional standard, the court is not going to say that you have made the standard of care. And I'll give it, like I said earlier, a clear example. In the city of Lagos, The people that drive what we call downfall buses, they run the traffic lights with impunity. It's almost like the standard practice. They don't stop at traffic lights. So if one of them should run into another person's vehicle or injure a road user, and they come out and they cannot come to court and say it is their standard practice. We run the traffic lights. In fact, what they are doing is committing a crime. So that is their standard practice. So in that context, they are not going to be able to say because we have made the standard of the average downfall driver, we have met the standard of care. No. Neglect of duty, breach of the law, and all sorts of behavior that are not reasonable and in the connotation of the reasonable man will not make you escape the condemnation of the law. So these are some of the considerations, and I would expect that we look at some of the cases. Then the court might look at the practicability of taking precautions. The court sometimes weighs the risk of injury against the cost of taking precautions and look at where the loss would fall in determining who takes the blame, because there are economic considerations in the law of tort. There is an economic angle. If you look at the theoretical foundations of the law of tort, you look at the cost and practicability of taking precautions against the cost of the accident. And if the cost of the accident of taking precautions is much lower than the cost of accident, then the person who fails to take those precautions has breached the standard of care. So if you take a case like Latimer AEC, where it was proven that the factory was flooded and the defendant had done everything to reduce the likelihood of accident. They've tried to clear the water, they had put sawdust, they had done everything to reduce the risk of an injury. And this claimant was still injured in the course of using the factory. The court said that the only thing that could have happened that would have prevented his injury was that they shut down the factory. And when you weigh the cost of shutting down the factory against the risk of injury, the cost of shutting down the factory was much higher. So their behavior as occupiers of that factory was reasonable. So this represents how the law determines the issue of breach of duty of care. They look at the objective test, and they look at the test in the context of the reasonable man standard. And we have defined the reasonable man as a notional man in law created to evaluate the actions of a defendant. It's not a real person that is brought before the courts of law. And we have said that it creates an objective standard. The court therefore looks at that standard to determine most activities. In very few situations, the law may take note of a peculiar defendant, for instance, a child defendant, and they haven't determined who is that reasonable person in that context. Then the court looks at some factors to determine whether you have made that standard of care required of you. These are some of the considerations that assist the court in determining a breach of duty of care. Thank you very much. I hope to see you in the next presentation.